Good afternoon, everybody, and welcome to today's webinar. My name is Zukiswa Pikoli, and I am a journalist at Maverick Citizen. So today we'll be discussing the traditional courts bill and whether or not it's constitutional. As some of you may know, it's been quite contentious and hotly contested. And so today we have the best possible people to come and help us unpack exactly what is happening with this bill. We have Nolundi Luwaya, who's the director of the Land and Accountability Research Center in Cape Town. And then we also have Mavuso Msimang, who's a prolific activist, as well as an environmental consultant. So I just want to let everybody know that we'll be taking audience questions. So please feel free to post your questions. And as and when we can, we'll try and get to as many of them as possible. So just to give a bit of background, which will mainly be discussed by my guest, but the Traditional Courts Bill was passed in the NCOP last year on the 2nd of December 2020. The NCOP passed this bill and then it was now referred to Parliament, to the Justice Committee to then discuss it further and decide whether it was going to be passed. The MPs in the Justice Committee subsequently found that there were some holes in this bill and they referred it for a legal opinion. So the legal opinion is imminent and it's hopefully coming out soon. But while we're still waiting for that to come out on whether or not it really is constitutional, we have our two guests here to help us discuss it. So I think I'll just jump straight in and ask Nolundi to give us a bit of background on the bill, where it comes from, and this long journey, I suppose, that it's had.
Thanks, Zukiswa, and good afternoon to everybody who's joining us. The history of the Traditional Courts Bill is quite a long one. The bill stretches all the way back to 2003, when the South African Human Rights Commission produced a draft bill, which it had formulated after an extensive public participation and public hearing process, in which it spoke to a range of people. That version of the bill was rejected, and a different version was introduced in 2008. This was a version that was incredibly contentious. It was a version that did not allow for opting out. In fact, it made it a criminal offense to opt out. And it had some very controversial provisions in terms of its treatment of the ability of women to represent themselves. And it had very extensive sanctions that the court could impose on people. That version lapsed, and the same version was reintroduced in 2012. The version of 2012 was, went through the parliamentary process over a span of years. And in 2014, that version was actually unable to secure the majority support from the majority of provinces, and therefore was not able to pass. There was then a period in which the Department of Justice, through the Deputy Minister, John Jeffrey, engaged in a reference group process that involved civil society organizations, traditional leaders, and other stakeholders. And from that process, there emerged a version that was introduced in Parliament in 2017. And that was a version that really reflected the process of compromise that had happened in that reference group space. It was a version that did provide for opting out, that had better protections and treatment for women. And it was a version that really kind of gave us hope that it would be possible to pass a bill that was more aligned to what it was that rural people had been asking for the longest time. In the 2017-2018 parliamentary process, the National Assembly's Portfolio Committee made substantial changes to that version of the bill. And under the direction of the then chairperson, Dr. Matole Mochecha, all of the references to the consensual voluntary nature of customary law were removed, and the provisions that dealt with opting out were also removed. And that's the version that's currently returned to the National Assembly, having been only slightly amended by the National Council of Provinces.
Okay. So can you tell us a bit about customary law and where it fits in a constitutional democracy?
Sure. So South Africa, like many legal systems, is a pluralistic system. What that means is that we recognize more than one system of law. The Constitution and the Constitutional Court have made it very clear that customary law is a part of South African law and that it is afforded the same status as what is termed the common law. The Constitution quite openly recognizes people's ability to choose a cultural life that they wish to live under. And within that context, one could argue people have the option to practice customary law as they wish. Customary law is, of course, subject to the Constitution, given that the Constitution is the supreme law in our country. And therefore, all of the elements of customary law need to be aligned to the Constitution and deemed constitutional. So really, the kind of idea that I subscribe to is that South African law is made up of both of these systems, that ultimately what we're talking about here is a single body of South African law that has these various elements, customary, common law elements, but ultimately it's all one body of South African law.
Okay. And so what kind of cases would you say are likely to be heard in something like a traditional court? Assuming, of course, well, not assuming, but knowing that it's obviously different to our main system of law or the court system.
Sure. So in answering that, I think it's important to bear in mind that there is a difference between what the traditional courts are allowed to hear within the ambit of the Act. So the Act in Schedule 2 sets out a range of the types of offences that the traditional court can deal with. And then, of course, there's what happens in practice, right? There's the types of cases that people in their own communities take before the traditional court. The traditional court's bill itself lists a couple of types of cases. Amongst those are theft, as long as that's under 15,000 Rand, damage to property, as long as that's also under 15,000 Rand, assault, crimen injuria. And then it says that the traditional courts can give advice on a range of customary law practices, which include ukutwala, initiation, customary marriage, inheritance, succession, and then something that they call customary law benefits. So there's what the Act prescribes, prescribes. And of course, the question is, will that be what actually unfolds in practice? Will traditional courts, should this version of the bill pass, will they only hear those matters? Or will they, extend their reach? It's important to note that in the traditional courts bill, as it stands currently, there is a catch-all provision that says that the traditional courts can also hear any dispute between members of the community. So that's quite a wide phrasing. In terms of what people bring to the courts in practice, you see a range of issues coming before the court. People bring matters related to, in some instances, rape, matters related to sexual violence, which are under the bill explicitly excluded. But people also take matters, that are of importance to them. So disputes around fencing, possibly disputes around somebody's goats having, wandered into someone else's garden, and those types of disagreements.
Okay, all right. Dr. Mavuso, I just want to bring you in here. You obviously have lent your voice in terms of also, questioning the constitutionality of not only the Traditional Courts Bill, but also the Traditional Courts and Leadership Act, which we'll get to at a later stage. But what would you say is your main bone of contention here?
I find it extremely difficult. Thanks very much for this get-together, and thanks to Nolundi for her expert, intro on these matters. I just find it very difficult that when there already exists an example of a good law, an acceptable law, that Parliament, led by the ANC, which was voted into government by most of the people that we are talking about, should find it easy to change the bill to a situation in which it inconveniences them. I mean, there is reference to the opt-out, removing the opt-out and participation voluntarily, and making traditional courts function like legal courts. These are things that are very obviously disadvantageous, detrimental to the interests of the people. So I'm saddened by the fact that we have an ANC government, an ANC portfolio committee leadership that is grappling with things that are very, very clearly retrogressive, trying to put them in place or defend them. I mean, to continue working under the framework de facto of the former Bantustans, to consign certain citizens, to deprive them of the common South African citizenship, is something that I really don't understand.
I mean, you have to then ask the question, right, that the ANC fought so hard for this democracy, right, fighting so hard against these very Bantustans that were brought on by the apartheid era. And yet they're still insisting on having a bill that still harkens back, to the Bantustans. So my question then becomes, how important is the issue of rural people and what happens in rural areas under traditional leadership? And why do we continue to have demarcations based on Bantustan sort of divisions?
There is no logical explanation for that. 17 million, some people say 18 million people are in rural areas now. This is a third about of the population of South Africa. You cannot be unmindful of the fact that you effectively exclude them in some very important aspects from the constitution of South Africa, or laws that govern the rest of the public. You're dealing with land here. If you are going to allow people, because they are traditional leaders, some of them, by the way, the traditional leaders imposed by the apartheid system during the Bantustan era, if you take away their rights and give it to those people, it really does not make sense. One can only speculate as to why they do that. I think it would be, I don't know, are they aware of what they're dealing with? That's the kindest thing you can say about them. But you could also ask whether, is there anything to gain for the ANC in treating these matters?
Yeah. Oh, I think that Mavuso is frozen there. But Nolundi, just to go back to you, do you get the sense that government is ignoring you in favor of maybe pandering to the interests of traditional leaders? Is that the impression you get?
Look, there certainly is a lot of deference and a lot of pride of place given to the thoughts and requests of the traditional leadership collective. And I think that does come at a price. I think it does come at the price of excluding the voices of rural people. The traditional courts bill and the processes related to its progression through Parliament are a prime example of how hard and how loud and how consistently communities that will be living under this law have said, this is not what we want. This is not what we need. This does not align to the type of customary law system that we ascribe to. And so it is difficult to not say, yeah, it does sound and feel like the lawmakers are ignoring the voices of the people who are going to have to live under these laws. And, given the shape and the types of amendments that are made, they certainly do seem to serve and place in a better position traditional leaders over the people who reside in those communities. I think that there's a wealth, a network of rural activists who can speak with absolute authority to how many times they have been to public hearings, how many submissions they've put forward. It's not that people have not spoken up, but it is in truth that what they're saying has been ignored.
Yeah, because obviously the government from their position are saying we've had the consultations and this is what the consultations have brought back. So then that makes you question whether or not, that kind of feedback is accurate enough.
Yeah, absolutely.
So, you're saying that the bill has gone through different versions of the bill, right? And then it came back now in its current form, and the opt-out clause has been taken out again specifically. What's your assessment of this insistence of including this very controversial opt-out clause?
So the key thing about the opt-out clause, Zukiswa, is that it's about accountability and it's about choice. The value and the legitimacy of traditional courts is determined by the people who use them, right? where people feel that the court, the kind of council that convenes the court, has legitimacy, responds appropriately to what it is that they need, you'll find that the courts are used. People come from far and wide to bring their matters to the court. And so the opt-out provision is about recognizing that the authority is a bottom-up authority, that it's this idea that people must be allowed the opportunity to, where they feel that the court does not hold legitimacy, where they feel that they might not get a fair hearing, they have the ability to exercise the choice to not use the court. It isn't about saying that this is about undermining traditional leaders, but rather this is actually about subscribing to and respecting a deep principle of customary law. This principle of, voluntary affiliation, that this is a system that is based on people opting in, subscribing to it. There's a lot of historical research that shows that, historically, people were able to vote with their feet. In a time of war, if a traditional leader could not sort of garner people's support in his choice to go to war, he would struggle to rally the troops, if you will. So really, it is a system where there is a give and take between your ability to lead and the fact that it matters whether or not people are willing to follow. And so the inclusion of the opt-out honors that principle, but also makes sure that people are not locked into a system where they might be subjected to, terrible abuses of their human rights.
Yeah. Dr. Mavuso, I just want to also understand from your side. I mean, you're somebody who's quite senior in the ANC, right? I'd like to understand what's the thinking around an ANC government that doesn't have the interests or is not listening to people, right? It's there to serve the people, but it's not listening to what the people are saying. And yet it's meant to be a people-centered government, right? So the question then becomes, is it because they don't understand how things in the rural areas work under traditional leadership? Do they not understand what Nolundi just explained now, that there has always been an element of being voluntarily associated with the traditional leadership? You weren't just kind of foisted on there, and that's what you had to live with. Do you get a sense that there's an understanding and a grappling with what it means to be, in the traditional rural areas under traditional leadership? Oh, I think he might be frozen again.
And meeting certain criteria, I do not occupy any position in the ANC. But yes, I've been around and have worked with some of the leaders, most respected leaders of the African National Congress. I was trying to say a little earlier that representative should take, can you hear me?
You're back. Yeah, you're back.
Oh, I don't know what's happening here. I'm sorry about it.
Oh my, and then he's gone again. Okay. Okay, I think maybe let's look at some audience questions. There's a lot of questions on here. Okay. Oh, there's a comment here which is quite interesting. So from Ian Huntley says, I think it's time to dump the feudal provisions of the traditional courts bill. We fought and struggled for democracy. I don't know if you want to respond to that, Nolundi. Do you agree with what Ian is asserting here?
I mean, I think it's probably a little bit more complicated than that, right? So opposition to the traditional courts bill isn't necessarily opposition to the entire institution of traditional leadership. I think the key thing is that people must have the choice. People who live in rural communities are openly saying, look, we may not have a problem with our traditional leader, some of us do, but the institution is part of, the customary law system, it's part of a way of life, and it is, of course, recognized by the Constitution in accordance with customary law. So I think the key thing is not to kind of, paint this as a wholesale opposition to the entire inclusion of traditional leaders, but rather that this is about ensuring that the traditional leadership institution, practices, and the systems are aligned with the Constitution and are, centered around making sure that people are in the power position.
Yeah, for sure. Then Mavuso, I see you're back. I don't know if you want to pick up your question again. I think it might be me. Every time I say something, then he freezes. Okay. There's another question here from Victor Komape. Victor says, why should there be two justice systems in our country, in one country? One for rural folk and another for urban folk. Those courts don't recognize legal representation. One's legal and constitutional rights to question and cross-question, to appeal, etc., are not recognized. Women are not recognized in the name of tradition and custom. I think the woman question was bound to be thrown in there at some point, but I think maybe you can explain that a little bit more.
Yeah, but I mean, that's a really good question. Nolundi has explained that I don't think anybody is against traditional leadership, the traditional leadership system per se. I think our constitution recognizes that people do live under those kinds of, is that people are refusing a progressive, supposedly progressive party like the ANC should have to be jolted, reminded, that women, in terms of the constitution that they have passed, need to play a role equal to any other person, that you can really have women being represented by some other ANC with the highest ratio, proportion of women. Is this token, or did it just happen because some people were in place to enforce this? So I think the existence of the two systems is not, in my mind, an issue per se, but it is giving authority to people who don't and who are not trained. For instance, when you expect traditional leaders to play the role of a court of law when they have absolutely no training.
Oh, this connection is not great.
Am I back now?
Yeah, yes, you are. You're back. You're back.
Yeah, sorry. So I mean, I am repeating that the existence of the two systems is not an issue per se, but it's the application, it's the use, it's the retrogressive steps that are being taken by people.
Oh, okay. I think let's just move on to the next question. So what I wanted to find out from you, Nolundi, is the fact that the bill was passed in the National Council of Provinces, and then it got to the National Assembly and was not thrown out but referred for a legal opinion. Does that suggest that there's elements in the bill making system that might be actually, speaking to what Mavuso was saying, retrogressive, right? That you allow for something to go through that already has questionable constitutionality, and it makes it all the way to national parliament for it to then be referred for a legal opinion. Surely there should be some sort of checks and balances that are done before it even gets to that point.
I mean, look, we were very surprised when the National Assembly's Portfolio Committee called for a legal opinion. We had anticipated that they would, sort of pass the bill with minimal engagement. And so it offered, one hopes a kind of an opportunity for further discussion on the bill. I think it is their decision to source a legal opinion is twofold. It's one, based on the fact that the Portfolio Committee's composition has changed. And so the Portfolio Committee that would have dealt with the bill back in 2008 is obviously a different composition to this committee. And so it seems that there was some kind of, not being fully familiar with the bill. But in terms of the point that you're making, Zukiswa, about, whether this raises questions about the lawmaking process, I would say that it does. I think we've seen, certainly in the area of customary law, quite a few of these bills being, eventually referred to the Constitutional Court and ultimately referred back to Parliament for amendments and adjustments, because the Constitutional Court has found that there are constitutional misalignments. And so there is a sense, I think, from some parliamentarians that says, well, how is it that we can keep passing these bills that then get bounced back to us by the by the Constitutional Court for us to fix them? What is that saying about our processes, and are we doing it thoroughly enough? And certainly, when it comes to, what's been termed the Bantustan bills, the kind of collection of laws that includes the Traditional Courts Bill, I think what we're seeing is the fact that Parliament isn't actually fully trying to understand the system that they are trying to regulate. There is a misunderstanding. There's a lack of a full kind of grasp of what it is that one is trying to regulate in passing these laws. And then that, of course, leads to a misalignment, a misinterpretation, and ultimately it leads to a final act or bill that is not constitutional and needs to be referred back, whether on procedural or substantive grounds, for a correction. So certainly, there's something happening in the lawmaking process.
So your generous assumption that it's more
I think it's a very
capacity than an intentional will not to pass bills that
I think this is a very generous assumption, absolutely generous. But I think there is a danger in that. There is a lot of pressure. Interested parties must be leaning on government, on MPs, on ANC people. For instance, the mining companies and the BEE groups, this act with a difficult name, Mine Minerals and Petroleum Resource Development, insist that there should be BE in any business that's given to those people. So you find that those people do have an influence. These are people who may not even come from the area, who then constitute the BE partnership with the mining company. And the people are ignored. It's as obvious as all that. So the ANC can't have lost touch with the people to the extent that they are not aware. I think people are leaning on them. And some of the people are offered something if they accept certain things. It's a phenomenon that you really would be blind not to recognize. And you need to look at that. The issue of voting too. I mean, rural areas, if the ANC is not strong on the ground and it can form a partnership with traditional leaders in Contralesa, perhaps what they could do in return is give them the powers that really traditionally did not exist, so that they gain something. So there is a motive. There is no doubt about that.
So just picking up on this point that you're making now in terms of motives and the ANC wanting to align themselves with traditional leadership, there's a certain perception that traditional leaders seem to be getting further and further away from the people. So they're not necessarily about serving people, because now they're also being paid by the state, right? And to a certain extent, it may well be, within their interests, to subscribe to such acts, such bills, but also sort of bringing in the Traditional Khoisan Leadership Act, right, which was also an act that was very contentious. One of the things that was brought up is that traditional leaders can now make decisions on behalf of communities and the land of communities without their consultation, right? One of the big things there is about mining, meaning that, they can give away mining rights and end up getting, unduly enriched at the cost of communities who may then be dispossessed and disenfranchised of their land, where would you say this fits in all of these discussions in terms of the distrust that's also there with the traditional leaders, but also why they're not necessarily raising too many concerns about this bill?
So I think that there is a very, very intimate relationship between, these bills and these acts. And so the Traditional Courts Bill fits in the sense that what it does is, if the, not even if, when the Traditional and Khoisan Leadership Act commences and comes into effect, these powers that you've been describing, that traditional leaders will now have to enter into agreements with the third party with minimum sort of consultation. Adding the power to effectively sanction people, to bring people to the court, means that if you have a situation where perhaps there are members of the community who are opposing a particular agreement, who might be asking difficult questions, in the event that those members have a dispute that they bring to the traditional court, this adds an avenue to almost sanction them for sort of daring to question your power. You could find a situation where someone who might be an activist in their community is potentially summoned to the traditional court. It has happened. We have examples of where that has happened. A woman in KZN spoke in Parliament and was summoned to her traditional court by her traditional leader to account for why she spoke in Parliament. And you would then sit with a traditional court that's empowered to really exercise an authority and to sanction that person in ways that can have serious consequences. So in many ways, the Traditional Courts Bill brings the kind of enforcement arm into play here, right? So the Traditional and Khoisan Leadership Act subscribes particular powers. The Traditional Courts Bill then brings in the ability to exercise a form of enforcement and potentially to silence people who might be in opposition or who might be asking difficult questions. So there is undoubtedly a relationship, and there is a form and a system of governance and empowerment that's been constructed here. And I think Mavuso's point about, the mineral resources as being a central factor around which this type of governance system is being constructed is something that we can't ignore because it does play a critical role. The stakes are high, actually. In a sort of twist of fate, many of these rural areas are where the richest mineral resources lie. And we're talking about billions and billions of rands here, actually, in reality.
That Mavuso, should traditional leaders be paid by the state?
Oh, yeah,
Would that not help things along a little bit?
I wouldn't mind them being paid by the state per se, as long as we define their role very clearly, as long as you don't take people's power and give it to them, as long as you train them to exercise responsibilities for which they are not trained. That is really, as long as you do not take away, for instance, the key thing about consulting with the participation whenever you do these kinds of things, that you must consult at grassroots level. I think you can pay them, but they must know that that doesn't entitle them, and you must not. You could pay them, it eases up things for the communities, but they should not be allowed to move away from customary law, because that's what the Constitution still recognizes, because that leads them to take away power from the people on the strength that they are their seniors. I mean, sorry, just to say that the Motlanthe, investigation, I can't remember, was a high-level presidential advice. The bill should be suspended or scrapped until there is consultation with people on the ground. I don't know why they wouldn't listen to their own commission of inquiry. I think this was set up by Parliament, if I'm not mistaken. So there is really something quite egregious about why the Party of Liberation should really act in this manner. It's probably some of the things we're seeing in the broader area where money is increasingly playing an important role in these things.
But I think there's a lot to be said about not listening to your own inquiry. I mean, I think there's a track record of not listening to their own inquiries. It wouldn't be something that's out of the ordinary, which again goes back to the issue of being alive to issues that pertain to people and being responsive to things that are important to people, particularly on the ground. But I just want to ask Nolundi, as a layperson myself, I mean, I'm obviously also still trying to understand this like everybody else. Should the Traditional Courts Bill, now that you've actually said it's not, it's not legally binding, should it be located within the Justice Portfolio Committee? would it not be better located with, rural development or COGTA to be discussed there if there's no real legal implications of it?
So, I mean, this is an interesting question, Zukiswa. The current version of the bill makes traditional courts into courts of law, which then, on an understanding of how South Africa's judicial system is constructed, would place it within the ambit of the Justice and Constitutional Development Portfolio Committee, and within that department. I imagine that, the kind of the logic that informs why it's under the ambit of the DOJ is because it is about kind of crafting a legal system and recognizing that the bill in its current form does imagine an interface between traditional courts and magistrates' courts. So currently, even though it doesn't provide for opting out, and even though it requires that once a person has started in the traditional court system, they need to go through all of the various levels. Once they have, completed that process, the bill allows for you to take the matter to the magistrates' court for that matter to be heard anew. It also allows for a procedural review to the High Court. So given the kind of proposed interface between the current, sort of civil justice system, it seems that it is correctly located within the ambit of the Justice Portfolio Committee. But of course, there are a multitude of questions and challenges with how that interface is going to work, right? We all have a sense of how our magistrates, courts and high courts operate, that it's a system that's based a lot on written evidence, being able to file the appropriate papers, etc. And there are serious questions about what type of support is given to somebody who would want to take a matter that was heard in the traditional court to a magistrate's court. How do they, get supported with the legal representation, and how exactly do those two kind of processes and those two systems speak to one another?
Mm. So in the eventuality that a person would bring an application, for lack of a better word, in the traditional courts, against a traditional leader, how would that work if the traditional leader is also now presiding over that whole proceeding?
This is a critical question. I imagine that, the bill would allude to a traditional leader needing to recuse themselves, and that, they can appoint, so the bill allows a traditional leader to appoint somebody else to act in their stead, to act as the person who presides. And so one imagines that that is what should happen. Whether or not that is what will happen is a whole other question, right?
Yeah.
So in a way, systems like that, rely on the person doing the right thing. So you're relying on the traditional leader saying, look, this is a matter that involves me. I actually am not going to preside. I'm going to ask someone else to preside. In the event that they don't do that, there is a big question mark as to what happens, what remedies do people have if you are bringing a matter against the traditional leader who would preside over that court.
All right. So I'm going to take an audience question now. Bronwyn Smith is asking, is the opt-out clause a sufficient protection? Will people know their options and truly be free to exercise their choice should they want to opt out? The balance of power is so strongly in favor of the ruler as opposed to their subject. Are people truly free, informed, and empowered to opt out? And will they be able to do so without fear or stigma or repercussions in their community and or from their traditional leader?
Look, I think the opt-out clause is not a foolproof and perfect solution. I think Bronwyn's question is very pertinent. There is always the reality that people won't know that they have the ability to opt out, and that, even with the ability to opt out, people may still be subjected to certain repercussions. But I would offer the opt-out and the importance of its inclusion as a baseline, right? At the very least, what you're doing is you're saying it does exist. And there is an avenue. And even though it is imperfect, it certainly is, I think, a much better formulation than having no recourse, having no option, and having no ability to actually choose whether or not you wish to appear before the court.
Yeah. So I just want to pick up on this and throw this to Tadu Mavuso. Part of what Bronwyn is asking here sort of leads to this impression that people have that people in the rural areas lack a certain sense of agency, and they're sort of just subject to this almost tyrannical rule, and they're sort of living in a constant state of fear and are disempowered, and those kinds of things. Is that your impression of South African rural people, that they have no agency and are not empowered?
Is that my question?
Yes, that's your question.
Yes. No, that's absolutely the case. That's not to say there aren't progressive traditional systems, traditional courts. I've attended meetings that were called where people said, listen, we do not have the training, the background to implement the things that are being said. But also people tend to respect those in authority and would be guided pretty much by what you're saying, that if the consciousness of the person who may be conflicted exists, then the system will work. But more often than not, that's not the case. There are very many. So the Bantustan system also, I mean, we know that there are very many people who were made traditional leaders when they were not. They were put in place to serve the system. So you don't expect very much of people like that. I don't know, I haven't done any study of the whole system, but there is a requirement to try and protect the rights of the people on the ground, because the traditional court system across the land is really far from perfect.
Yeah. Okay. So for the average South African watching this right now, why should they care about what's happening in the rural areas? They don't live there. Why is it important?
So I would say that, I think it's important because this boundary or barrier between urban and rural is a lot more porous than we think it is. It's important because, people are living in these areas, even if you aren't. And this is a genuine and real threat to their ability to live in a manner that aligns with the Constitution, that provides them with the opportunity to make the choices that they wish. Ultimately, I think, what makes that kind of border, if you will, between urban and rural a lot more porous is that people don't live in kind of neatly boundaried ways, right? You're not just an urban person, you're not just a rural person, but you live in a way that kind of crosses both. And so ensuring that there isn't the development of a separate system in which people are relegated to a kind of second-class citizenry is everybody's concern. Because it's about constructing the one united South Africa that was fought for so hard, and that the Constitution ultimately, envisages and asks us to strive for.
Yeah. But Mavuso, why should they care?
Well, I think in the first instance, maybe things are changing as we progress. Most people in urban areas have a makaya. They've got in the rural areas.
Yeah.
It really is in their interest that the people Basekaya receive treatment, they receive the same kind of rights, have the same kind of rights as people in the urban areas. When things are tough in rural areas, people come to the urban areas to look for jobs that are increasingly not available. They do become a burden on the family system when in fact they could easily be existing and prosperously in rural areas. I think there is an interest, there should be an interest in every way. The two are not in conflict, to my mind. The problem only occurs when the clever ones, the ones who are favored by, association. We talked about BEEs who become partners to mining people, and then they go like the mining houses. They will totally abuse and the people in rural areas. I guess for them, ignorance, for these guys, the ignorance or the powerlessness of the people becomes an advantage. But seriously, I think it's very important for every South African to recognize that the rural areas are living areas, and there are people there with a system that has over centuries functioned properly. It needs to be upgraded, topped up as things change, It doesn't need to, it must not be destroyed. But I think people are just to stuff.
Yeah. Okay. So just, I guess maybe so people can get an idea of what demarcations that aren't neat little boxes like Nolundi just nicely described for us. What would that look like? What would, traditional leadership according to non-Bantustan borders look like? What would you envision that being, and how would that function?
So it would be a system, I think, that honors the idea that people ascribe to and they voluntarily affiliate with, a traditional leader, a system that resonates with them, a system that responds in a way that they feel is legitimate, that they feel is fair. And so, interestingly enough, the Traditional and Khoisan Leadership Act sets up a system for the Khoisan communities where people are not necessarily kind of bound within these particular borders and boundaries, but rather they actually affiliate with and are associated with a particular traditional leader. And that presents a model that, I think could work in the former homelands. This idea that people willingly say, actually, I affiliate with, traditional leader X, or, I affiliate with traditional leader Y, and to kind of disengage from this idea of locking people in based on those apartheid boundaries that were crafted, with a particular invidious kind of separate development model in mind. So I think actually, if we look closely at the type of model that's proposed for Khoisan communities, it could begin to give us a way to reimagine how people could voluntarily associate and affiliate in a way that's not bound by this kind of geographic jurisdiction, but rather by a consensual choice.
Okay. So I'm going to take another question. Lorato Zigalala says, to Nolundi, do you think that the government is allowing these measures to be passed even if they may be unconstitutional to appease traditional leaders, knowing that the bill and later act may not see the light of day because it will be set aside by the courts? Is this not a risk-free gamble to appease a certain sect while knowing that it will not take effect?
Look, I think it's very possible. I think that there is clearly a real kind of pride of place that is given to traditional leaders. They are often the first kind of port of call for consultation on legislation dealing with communities that fall within customary law systems. And certainly there seems to be, as I said earlier, a lot of deference that's paid. So I don't think it's far-fetched to say that the kind of lawmakers are in part relying on civil society objections and ultimately potentially constitutional court challenges to balance things out. Of course, the question is, how and why does that seem like a logical way to do things? Why not just listen to people within the lawmaking process versus kind of relying on civil society and opponents to take things to court? But yeah, it could very well be that there is this hope that there is ultimately the backstop of a possible constitutional court challenge.
Okay. So I just want to take us back a little bit, and you say that the current version that's before Parliament at the moment, there seems to be an assertion from Department of Justice that there was consensus on that version, and yet you, as activists, are contesting this. How would you respond to that assertion that there was actual consensus, and yet now we're here?
I would say, Zukiswa, that it's misleading. The consensus was around the version that emerged in 2017 as a result of the reference group process. And, I think that there are people potentially watching the webinar who are actually part of that reference group process, who could speak to that with more authority. But the version of the bill that emerged from that reference group process, that's the bill on which there was some consensus. The version of the bill that then has gone through the previous portfolio committee under the chairpersonage of Dr. Motsecha is not the same bill. So the bill that the National Assembly's Portfolio Committee is looking at now markedly differs from the bill that emerged from that reference group process, which is a version that, was certainly more acceptable to civil society organizations and I think to rural communities as well. So it's a kind of a confusion, making it sound like there haven't been substantive amendments made to the bill, and seeming to make it as if civil society is kind of, flipping around and now opposing the bill. But I want to be very clear that there were substantial changes made, and those two bills are not the same bill.
Okay. So, Tatu Mavuso, what would you say rural democracy looks like? What would a model of rural democracy look like?
I would be so happy, for instance, rural society must not remain static as areas of poverty. We do not really have an effective rural development program in our country. If you had, you'd
It's gone again.
Of areas to get things they need. So I think an antidote to some of these things would really be to promote very serious development programs and not leave people to eke out an existence in a manner that they have done for a very long period of time. We must be very careful, I think. This has been underlined time and again, that you do not, you employ a system that is that suits the people, but be careful not to alienate them from the basic rights that other people have. As soon as that red light seems to flip, then must know that something has gone wrong. But I think a lot of the problem is to do with the fact that there is very little development, talking generally, economic, everything, and a lot more could be done. I'm tempted to say, for instance, they've legalized cannabis now. Studies show that the commercial type of cannabis could actually be grown in a hectare of land, maybe by 7 people. Some of the climates there, Eastern Cape, Limpopo somewhere, you can have 3 harvests a year. These are all things where the government would put in very little money, such as fencing the area, but where people would be usefully engaged in income generating activities. I think then you would start where you'd open up roads and bring in other forms of technology. I just think that part of the problem is that our rural areas have not really received the kind of attention that it needs from government.
That's right. Nolundi, there's this impression that there's no such thing as democracy in the rural areas or under traditional leadership. So when you talk of rural democracy, how do you see that answering that question or that impression?
So I think that there is democracy within the rural areas, but I think that it's being very actively suppressed by, certain traditional leaders who operate in a way that seeks to really erase and silence people's ability to make democracy real in their communities. And so for me, rural democracy is inherently people-centric. It's about saying that there are people who live in these communities who know exactly what it would take to live with a democratic system, who know exactly what it is that they need in order to build a democratic system. And where there is a traditional leader who, either is trying to suppress that or who's not willing to work with members of the community to build that, people must have the ability to, move in a direction where they can build the type of democratic community that they wish to live under. I would also go so far as to say that I think that customary law does offer some democratic principles. I'm certainly not protecting it wholesale and saying that it's perfect. There's no doubt that it is a system that can be unbelievably oppressive for women. But I do think that it has principles that can sustain a democratic vision. I think it has principles that lends itself to building a democratic vision. This idea of being achieved by the people, the centrality of practice, of how people live in terms of, giving content to customary law. These, for me, are principles and pillars that do align with an idea of democracy. So I don't think rural democracy is a contradiction in terms at all. I think that it is ultimately an expression of people's power. And certainly in my experience, that's what you're seeing rural activists and rural communities striving for, fighting for, the right to shape their democracy.
Yeah. Yeah. So this, customary law is one of those things that you never really hear about until you have something like the traditional courts and it's being contested. Most people don't even know that we have customary law in South Africa. I mean, is it by design that it takes such a background feature that most people, forget about it? I suppose it also, people forget about people in the rural areas because they're not immediately in front of them. But I just want to ask what your opinion is in terms of customary law and the fact that it takes such a backseat and isn't particularly central.
And I think it's disappointing that customary law takes such a backseat. As I said when I opened, it is part of our legal system. It is part of South African law. And I think that in part, the reason why it kind of gets relegated to the shadows is because it is being kind of built and crafted as a kind of ghettoized type of law, right? So it's a system that applies to those people over there who live within those apartheid geographies, who are separate from the rest of South Africa. And I think that cannot be allowed to stand. Customary law is taught as part of law degrees at universities in South Africa, and I think we need to work harder in making sure that we teach it robustly and that we teach it in a way that expands on, the developments, the kind of active nature of customary law. And I think that these are conversations and issues, as I said before, that are central to South Africa's democratic vision as a whole, and so need to be lifted out of the shadows and brought into the mainstream, which is why I think it's important, that Maverick Citizen is giving this kind of platform to have this kind of conversation, because I think there's a lot of work that needs to be done to allow the people who live under these systems to speak for themselves. There are a couple of questions in the chat about are communities in support of traditional courts or not. And I would say, of course, communities support traditional courts. People use these courts. They are accessible, they are familiar. And certainly given the type of backlog we have in our magistrates court system alone, they are the most direct access to justice that some people have. So I think, again, I just want to reiterate the point that an opposition to the traditional courts bill is not an opposition to traditional courts. It's an opposition to this kind of construction of a system of governance that relegates the people who use traditional courts to the status of second-class citizens. But certainly, I think that there is, robust use and support for traditional courts, and we need to be careful not to make, opposition to the TCB a wholesale kind of narrative that people don't want these courts. They need to be able to choose.
I think that's an important assertion, that you're not wholesale against it, but there's certain aspects of it that could be strengthened and made more constitutional. So we're coming up to the end of our discussion, sadly. We've got 3 minutes left. And I think in that 3 minutes, I'd like you to think about or speak to what happens if this bill just steams ahead as it is. What would be the next steps? So if you can, maybe Dad Mavuso can start with you.
Oh my God, yeah, it would be tragic, I must say. It really, really would be tragic. I hope it doesn't happen. I think, these things are very costly. The matter would have to be referred to the Constitutional Court. It takes time, it takes money, but that would be the only route that remained, because this would be a serious travesty. And just to add to what was said a little earlier, it would be a big mistake to do away with customary law and all of those things. People believe in these things, and where it serves well, it should be allowed. It shouldn't constrain them. It should be restrictions that surround it must be allowed to be removed as we go along. But no, I think it would be tragic to not allow to steam ahead with this bill.
Nolundi?
I fully agree with Mavuso. I think that you would probably see legal action being the next step. But I also think that rural communities then would, be in a very justifiable position to make the ANC kind of feel their disappointment, and if that's taking the opportunity at the polls to send a strong message that says, actually, this is not the type of governance that we deserve. It's not the type of governance that we need. And there will be consequences when people's voices are being ignored.
Okay. All right. Thank you. Thank you for that very interesting and enlightening, robust discussion. Judging from all of the engagement from the audience, people were very interested in what you had to say. So thanks everybody for participating in the discussion. I also just want to thank our Daily Maverick Insiders, which is Daily Maverick's membership community, for allowing us to keep our webinars free and open to everybody who wants to listen. And on that note, I will say goodbye to everybody and thanks for participating.
Thank you very much.
Thank you.